Hey everybody, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. In the next couple of minutes, we're going to talk about the biggest gift you can give your children. Before we get there, however, if you have any questions about estate planning or probate, you can feel free to reach out to us and have a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Now, every time we speak with a prospective estate planning client and they have children, we talk to them about the options available to them in designing the plan to protect those kids. There are a multitude of ways you can distribute your assets. You can distribute the whole thing outright, regardless of age. You can make distributions at particular ages. You can create a trust where someone else manages it for your children and only makes distributions in certain circumstances. You have the full flexibility to create whatever you wish to help provide for your children and guide them. Our firm typically starts at a standpoint in our advice for protecting your children with what we call a creditor insulated trust. We do this in such a way where there's a maximum flexibility for your children in that they get to manage the assets for themselves. They get to utilize the income throughout their life, and they get to use the principal for all of their needs. The standard which most attorneys use and is allowed by law and is the most flexible and yet a quote-unquote restriction, is called the HEMS standard: health, education, maintenance, and support. Of course, maintenance and support is a little bit subjective based on where they are in life at the time when they inherit the assets. But with that particular standard, even if, again, the kids are their own trustee, they get complete creditor protection, lawsuit protection, divorce protection. Even if they're a professional and there's a high malpractice chance in their industry, these assets are off the table and cannot be considered in any of those scenarios where their personal assets may be. Keeping in mind, too, that when we want this type of protection with our own assets, it's hard to get unless we give up some sort of control or use of those assets. This type of protection also for your kids is not something that we can necessarily add later, but if it becomes administratively, doesn't make sense anymore, or some scenario has changed in which this trust needs to be unfolded, it can be, but you can't add that protection later. So you should do so now in your estate plan. As a reminder, if you have any questions about estate planning or probate, please reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Thank you so much for listening, and if you found this information useful or think someone else may, please share, like, and subscribe where appropriate so nobody misses out. Again, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Thanks so much. Have a good one.